I hope you can see your way clear to letting this go, to let Flynn go. He is a good guy. I hope you can let this go. So for both of you, based on your focus on constitutional questions regarding the importance of independent and accountable law enforcement, do President Trump's statements to Director Comey in those instances give you pause?
They certainly give me pause, Senator. I think they're alarming statements, whether or not they rise to the level of what federal law defines as obstruction of justice. I'll just point out really briefly, the special counsel regulation expressly contemplates the prospect that crimes of the like of obstruction of justice, perjury, will be committed in the course of a special counsel investigation, perhaps with the intent to interfere with the investigation. So it's already in the mandate.
So would these kinds of comments reinforce for you the need to protect the independence of Director Mueller's investigation?
Certainly.
What about
Yes, I absolutely agree. You don't want to allege obstruction of justice until you know all the facts, but certainly this is alarming from that standpoint. And if you believe that the president might fire someone who's investigating him or his close aides, then the natural response for Congress is to try to give that person some protection.
Yes. So I want to get to the president's pardon of Sheriff Joe Arpaio. So the sheriff was convicted of contempt of court for refusing court orders to stop racial profiling. And before the sheriff even asks for a pardon, the president pardons him. It broke longstanding practice of presidents of both parties in several key ways. As I mentioned, the sheriff did not even apply to the Department of Justice for a pardon, has shown no remorse. What's happening now is that the Justice Department is now seeking to vacate Sheriff Arpaio's conviction. Are you concerned that the president's pardon of Arpaio sends a signal, this is for both of you again, to his inner circle not to participate in Mueller's investigation because he would have their back and pardon them, for example, for refusing to testify truthfully in response to a court order?
You know, I think it's a relevant consideration that one would want to worry about, but I guess in the end, they know that he can pardon them. Nixon's aides knew that Nixon could pardon him, and of course he never did, so I wouldn't want to draw any strong conclusions.
Well, the fact that the president pardons somebody who doesn't even ask for a pardon says a lot, I would say. Yeah. Did you want to add something?
Just very briefly, I think the Arpaio pardon, Senator, is a very good example of the very real prospect that a pardon could be completely unsupportable as a policy matter and, deserving of a political and public backlash and still within the president's constitutional authority.
Do either one of you believe that the role of the Justice Department is taking in seeking to vacate Arpaio's convictions further reinforce the need to have special counsel with independence from both the Attorney General as well as the Justice Department?
I think there are any number of episodes, Senator, that reinforce the need for there to be some modicum of independence in the Justice Department. I think that's not unique to the last 8 months. I think we see that throughout American history. And so to my mind, efforts to create permissible independence, permissible structures, permissible protections that separate the Justice Department from the politics of the moment are laudable and should be pursued to whatever extent the Constitution permits them.
Do you agree with that?
I do, and I would add, if you go back and you look at the record of the 1999 hearings about whether the independent counsel law should be renewed, a number of Justice Department lawyers testified that they frequently felt pressure of various sorts, not necessarily being bossed around, although that happened, but just they didn't want to investigate their friends, they didn't want to get in trouble with their ultimate boss. So there are concerns about this, there always have been, and that's an important reason to create forms of independence.
Thank you. Thank you, Mr. Chairman.
Senator Lee. Thank you very much, Mr. Chairman. I'd like to start back with you, Professor Posner. Why is congressional oversight not enough? I mean, we've got in the Senate alone investigation going on some of the matters being investigated right now. Why is the opportunity to investigate through Congress's oversight functions not adequate?
Well, I would use Watergate as an example. So the real break in Watergate occurred in a courtroom when Judge Sirica told the various low-level Watergate burglars that he was going to give them extremely long sentences, 40, 50 years, for a minor crime unless they started talking about what their superiors had said to them. And so Congress doesn't have that type of power, nor does the court also, the trial also created a lot of public attention about Watergate. Congress is not always able to command public attention. Indeed, what really broke Watergate was the Saturday Night Massacre. That's when it went from something that people knew about to something that everybody in the country was talking about. And that was, of course, a case where an executive branch official, not a member of Congress, was fired. So there are many reasons why the law enforcement side is very important for this type of problem.
And yet Congress does have it within its power to remove people from the executive branch. So this becomes a political action rather than a judicial action. But we do have that power. And so if the concern is, number one, that Congress can't scare up enough public attention, I beg to differ with you on that one, if Congress wanted to do it. Number two, if the concern is that Congress won't do it, we have all sorts of additional concerns that arise out of that. That becomes a question for the people, a question that I think would cause great concern in the people. In the few minutes I have left, Professor Amar, I'd like to turn to you. If the president has authority to give a particular order, and the president, in fact, gives that order to someone holding public office under the president's authority, can that be obstruction? If that person doesn't carry out that order after it's given, is that obstruction to remove that person, or is it obstruction to give the order in the first place?
Motivation might be very important. There are all sorts of things that are perfectly permissible, like, for example, voting for a bill because you believe it's in the national interest, but if someone paid you to do it, well, that would be a crime. So obstruction often turns on motivation, but Dean John Manning of the Harvard Law School has argued that actually, in general, it's good cause, and this isn't decided, and that's one of the reasons that good cause, as you mentioned before, Senator, is actually a problematic term. It's good cause to fire someone if you give them a lawful order saying, you have discretion to do X, you have discretion to do Y. I order you to do X and you don't do it. Professor Manning thinks that might be good cause. I think that might be good cause, but the bills don't say that. And if they did, then it would be, I don't think the bills want to say that because they want to create independence. But you can't be both genuinely independent and, as the Constitution requires, genuinely inferior. You can't be both. You have to pick. Congress keeps trying to pass statutes creating independence, and that keeps jamming with the gears that the framers set up. Whether you agree with Justice Scalia all the way down the line, he did emphasize inferior means inferior. He put that in a majority opinion called Edmund that actually commanded a majority of the Supreme Court. That's one of the many reasons I think Morrison is actually very vulnerable because of the Edmund test. Also, judges appointing prosecutors was horrible, even though two of the witnesses have actually said they agree with Morrison versus Olson on its facts, which is violation of Separation of Powers 101.
Right. So in other words, ordinarily, absent the special circumstances you've identified, if the president can give an order and in fact gives that order, that's not obstruction in the absence of the special circumstances you've
And you have to carry it out, and if you don't, you should be sacked. And if you can't, in good conscience, carry it out, the path of honor and law is to resign.
That begs the question, what do these bills actually do? If absent those circumstances, the president can give that order, and that doesn't amount to obstruction of justice, and a failure to carry out that order amounts to good cause, what's the purpose of these bills?
They're hoping that judges don't agree with you and me and Dean Manning on that point.
I disagree. I think the bills are meant to account for the possibility that you could have a case where everyone agrees that there wasn't good cause and where the firing was purely for, illegal reasons. And so I think if we're at the point where we're debating whether committing an act of obstruction of justice is good cause to remove a prosecutor, I think that if we're even having that conversation, Senator, I think that explains why we're having this hearing and why these bills have been introduced.
Okay, Mr. Chairman, I see my time's expired. I'd like to engage on that last point if I could.
You're now in a third round. You have 5 minutes.
Thank you. Thank you, Mr. Chairman. The chairman is kind and benevolent, and his state of North Carolina is a wonderful place. If that's the case that you described, where everyone agrees, we've got a problem. If everyone agrees, why isn't that an appropriate moment for Congress to exercise its authority?
It may well be, but I guess my concern is why I don't read the Constitution as saying that impeachment is the exclusive mechanism through which the executive branch can be checked in this regard.
I don't know that I disagree with that point, but I don't think that's the point we have to make, or the point we are in fact making. I think the other point is not that there is any, we're not asserting that there is any affirmative denial of the existence of an alternative remedy, but the mere existence of the three branches of government and the way they are set up creates that perhaps as the inevitable byproduct.
Senator, I agree with that. I mean, to be clear, I mean, none of this is without regard to the political levers, right, that will surely also come to bear if you had a case like that.
Professor Duffy, you looked like you wanted to weigh in.
I think the procedural aspects of this bill could actually be helpful to checking a special counsel, because a president that actually has some substantial cause might actually fear the political catastrophe of something like a removal order being called the Saturday Night Massacre. But instead, this actually gives a very rapid review, and the courts, I think, would construe the good cause, which is vague, consistent with standard principles of statutory construction. They'd construe it to be quite generous to executive power to avoid constitutional questions. And I think the president would say, we could have our day in court, we would likely win that and be more likely to say there's an orderly process to go through and to show that this or a particular special counsel has done something that has exceeded jurisdiction, or has done or has a conflict of interest, or done something else that really mandates review.
And if I may just really briefly, I mean, and just to amplify that point, I mean, one of, to me, the salutary features of the bills compared to the status quo, under the status quo, I think it's the case that if the special counsel were wrongly terminated, he could bring a declaratory judgment or injunctive action to enforce 600.7D, but he'd have to go to a lone district judge, right, with the ordinary mechanisms of appeal. Both bills, right, create expedited procedures for hearings before a 3-judge district court with a mandatory appeal to the Supreme Court. And so even if you believe, as I do, Senator, that the review mechanism is already in place, this to me is a better, more efficient, and if I may, less likely to draw a sort of outlier district judge way of solving this problem.
But better still, Senator, if I may, since everyone has been mentioning the Saturday Massacre, I just have to say the system worked then, and it worked then without an Ethics in Government Act or anything like this, and it worked because the American people and the House and the Senate actually decided what was good cause and what wasn't, and what stank and what didn't. And that worked better, and that's how the framers drew it up on the blackboard.
Just if we're doing the history, and Judge Cassell ruled in 1973 that that acting Attorney General Bork violated the regulation.
Way after the fact. That wasn't actually, what exercised everyone the day after the thing. There was no Ethics in Government Act.
We're going to let Senator Lee direct the discussion.
Yep.
In your remaining time.
Thank you, Mr. Chairman. The overriding concern that I have whenever we're talking about this area is that bad things happen when we depart from the 3-branch structure of the federal government. We have one branch that's in charge of executing and enforcing laws. Now, I don't always like the way that every president chooses to exercise that power. I have frequently disagreed with presidents of both political parties and the way they have chosen to enforce or not enforce the law in certain areas. We do live in a time that I think echoes back to us loudly that the fact that there are dire consequences from departing from that. Those of us who serve in the highly specialized individuals, but they don't work for the people. They can't be fired by the people. People in my state can fire me once every 6 years. People in the House of Representatives can be fired every 2 years. You can't do that. You can't have that kind of accountability with the people who work in the executive branch agencies. Moreover, when you combine the power to make law with the power to enforce law, that complicates the problem even further. That's why these are legitimate concerns, and I think it is not entirely satisfactory to say that either Congress won't always do it right or the president won't do it right. We know that to be true because human beings are fallible, they're mortal, they may be redeemable, but they're going to make mistakes. And you very often can compound that problem when you depart even further from the system of checks and balances put in place by our Constitution. Thank you very much to each of our witnesses. Thank you, Mr. Chairman.
Thank you, Senator Lee. Gentlemen, thank you for being here. We're going to keep the record open for a week. I'm sure that many of us will be submitting questions for the record. We appreciate your time, and I appreciate all the members' active engagement in this committee. The committee's adjourned.
That was fun. Thank you.